Hey guys, and welcome to the weekly docket. Got some good cases this week, starting in Wisconsin, heading to Florida, and then out to Idaho, which is particularly weird right now, and down to South Carolina for the Murdaugh cases. Let's get started. Let's start in Wisconsin with the world's friendliest murder trial. Another feel-good story it's always good to start with. This is the case of Zachariah Anderson, who is accused of murdering the new part-time boyfriend of his ex-girlfriend. No body has been found, but there's a lot of circumstantial evidence that foul play did happen and a lot of evidence that could implicate him, although, of course, he's mounting a defense. His first trial ended in a mistrial. His second trial, which just started, almost ended in a mistrial when the prosecution objected during the defense opening statement. The defense attorney had mentioned the girlfriend, and in a way that the prosecution thought suggested to the jury that maybe she had something to do with his killing, that she was responsible for it. And in Wisconsin, you can't do that. You can't name another person as the likely perpetrator unless you have a hearing first and can show the court that person probably did it. That way you just don't have out of the blue allegations of some third-party actor, and nobody's prepared for that. Well, the defense said that's not what we were trying to do, and the judge sent everybody away so he could study the law and listen to arguments the next day. And guess what? They worked it out.
And the filing so that we can keep going.
What did I do in my life to merit such congenial attorneys?
The defendant was in a good mood.
Do you have any questions about this at all, Mr. Anderson?
No, I'm good, Judge.
Okay, any problems? Okay.
The lawyer's in a good mood. The defendant's in a good mood. The judge is in a good mood. And he sends them on their way with this parting shot.
Enjoy this magnificent day. First day of meteorological spring.
Rare's the time when you'll see a courtroom, a murder courtroom, where everyone is so happy together. I doubt it stays this way, but it's a good way to start this broadcast. In Florida, or at least one of Sarah Boone's wishes has come true, as her attorney has not only engaged a private investigator, but has asked the court to allow them to hire a mitigation expert. Now, you see these a lot of times in death penalty cases where, as part of the death penalty consideration, you have to look at the aggravating factors and the mitigating factors, and it only makes sense to have somebody on the defense side who can find out those things and understands those and brings them to the attention of the attorneys in the court. You can also, though, see them in regular cases like this, where that person, because of the trade they're in, the specialized knowledge they have, they may be able to find things out that are beneficial to the defendant. So that's what they're asking for here. What was most interesting to me was the name of the place, at least as alleged by her attorney, is Prison Break Investigators. It seems like a good question on cross-exam. What's the name of the company you work for? But if it's the company I think it is, that is primarily ex-law enforcement people who do work for defense. So what that means for Sarah Boone is there's somebody that's going to be engaged on her side, if the court approves it, who will see her as a victim and try and help her establish that. So she's got to feel good about that. Let's head to Idaho and check in on Kohberger, the quadruple homicide suspect. I'd made a video before discussing how in Idaho, like in a lot of states, the death penalty has essentially been suspended due to prescribed formulas of lethal injection chemicals being unavailable. The companies won't sell to the states for this purpose. Some states have let this be a de facto repeal of the death penalty, while others work to change the formula. But another solution is just go old school and execute by another manner. Idaho is considering that answer with the possibility of bringing back firing squads. I mean, that's probably not going to happen, but it's interesting and it gives Kohberger something to think about while he's whiling away the hours. In addition to some rumors and leaks about Kohberger having pictures of one of the victims on his cell phone, accounts involving him around the Idaho campus, there's some actual definitive information that's come out of Pennsylvania where the court has unsealed some of the search warrants. The first that was released shows really just maybe kind of what he had on him at the time, pair of shoes, shorts, that sort of thing. Nothing exciting there, and he signs it at the bottom. But it gets a little more interesting when you get to his car, where the police see such things as swabs, Ziploc bag with a pink zipper, let's see, some change, gloves, receipts, hiking boots, a shovel, goggles, floor mats, reflective vest, used water bottles, a wrench, but here, a door panel, seats, seat cushions, headrest, seat belt, visor, fiber, brake pedal, gas pedal, phone charger, Band-Aid, wrappers, maps, documents, and a seat belt boot. So they took a lot of the car there. Now, his father signed a property return receipt involving a knife. It doesn't say anything more about it than that. A book with underlining on page 118. I wonder what that is. AT&T bill, a 40 caliber Glock, Smith & Wesson pocket knife, a laptop, green leafy substance in a green container. Okay. Documents, white paper with a password on it, power cable, a cell phone. Yeah. Some magazines for the Glock, some books, some face mask, black gloves, and a black mask. So some interesting items there. Does any of that lead to a smoking gun? We don't know. And it would be difficult to know due to the judicial efforts at secrecy for the sake of a fair trial. And of course, there's some opposition to that. And let's take a look at what's going on that front. The defendant filed a supplemental discovery request and the court sealing it, mentioning not only that disclosure of defendant's exhibit would compromise a fair trial, we know that argument, and be an unwarranted invasion of personal privacy, but also because the exhibit, quote, contains facts or statements that might threaten or endanger the life or safety of individuals, end quote. I looked at the statute, and that's not mere pro forma. It's an alternative ground that does not have to be stated if you have the fair trial one. So it really makes you wonder just what is in that exhibit. Maybe not as exciting as my imagination, but still, we don't know. The other front is that the Idaho Supreme Court will consider the media opposition to the judge's gag order. The court is also allowing the state and Kohberger to weigh in, and they all have to brief it up by today. Media argues these orders are subject to First Amendment issues. Yes, that's true. And that the order is deficient for several reasons. That's going to be argued. And the Supreme Court, because of the First Amendment interplay, must closely scrutinize this order. Here are a list of examples the media says show information of a wide variety being withheld because of, they contend, the overly broad and unwarranted order. A victim's family wants to speak with the press about the prosecution, but they feel bound by the gag order. Yeah, I don't think they should, though, just from reading it. But it says they feel that way. A Washington agency has requested declaratory relief to determine whether, consistent with the gag order, it can produce 911 tapes. I mean, they should be able to do that, so this one scores for me. Major Paris of the Pennsylvania State Police told a reporter he could not answer whether police had launched any review of unsolved cases that could be linked to Kohberger because of the gag order. Okay, he's even in another state, so I see what they're saying. Moscow Mayor Art, whatever his name is, told a reporter that his city attorney advised he could not answer questions about the overall community healing because of the gag order. Journalists' public record requests were denied by the sheriff's office, police department, etc., because of the gag order. Moscow Police Department issued a press release that due to this court order, they'll no longer be communicating with the public or the media regarding this case. Gary Jenkins, chief of police at Washington State University, other people told a reporter they could not answer whether Kohberger had applied for a graduate assistant research position with the Pullman Police Department because of this gag order. And then the police department even refused to answer how many cell phone towers are in the area. Okay, it seems like they should be able to do that. Near where the murders occurred, the size of his cell that he's staying in, the size of the jail, and even the nature of the meals because of the gag order. Now, some of these items may not be earth-shattering, and they certainly don't go directly to the issue of guilt or innocence or really say much about Kohberger at all, but that's kind of the point. The media is showing even obviously non-prejudicial information is being withheld due to the order. And at least in theory, this country has a strong respect in law and culture for free speech. Does it still? And the strict limits of government to suppress it. On the other hand, there are times when gag orders, appropriately limited and well-founded, are necessary in support of other rights like a fair trial. The gag order in Idaho is not the most sweeping we see right now. It's not even as broad as the one in the Indiana bridge murder case with Richard Allen. Still, the order was entered without much or any fact-finding based on party stipulations, and that kind of let's just get this entered and done efficiency might not be enough to support the order. So I could see the Idaho Supreme Court, if it grants the petition by the media, issuing some guidance on, hey, court, you are ordered to put in the record evidence of the publicity and substantiate your decision and the restrictions you're making. And so then the judge ends up redoing the order. I don't think the Supreme Court obviously is going to make some blanket ban on gag orders. That's not going to happen. But it could be that this order and the way it is written isn't good enough. I could see that. Staying in Idaho, we'll look at the Vallow case. And the judge apparently is considering new evidence the state is talking about the timing of the trial and has decided to delay Daybell's trial and sever that from Vallow's trial and go ahead with Vallow's trial in April because she wants this speedy trial. And the state says they won't have this DNA evidence potentially processed by then, so I don't know the significance of that. But it appears one trial will occur in April and the other later this year. Well, welcome back to the South, specifically South Carolina and the Murdaugh case. Started off the last day of trial with a little bit of drama, with a juror being dismissed, potentially for discussing the case. The main thing she had to work out with the judge was the dozen eggs that she had brought, and I think she ended up taking them with her instead of leaving them. Then the closings got underway. We'll talk about that a little bit. The state's closing, I thought, was a lot of anger and fussing. To me, it was not very persuasive. It probably didn't change anybody's mind who didn't think he was guilty to guilty. I don't think it did that. It had me wondering at points, and I think the guy is guilty. Maybe this case isn't as good as I thought, although I still think he did it. Then the defense side started their closing, and I thought they did generally a good job. A good job of showing that the state made mistakes in its investigation. Also, the state sometimes gave out wrong information, or as they put it, fabricated evidence, and that there were multiple explanations for the wounds that the victim suffered, for the timing of things, for who could have done it. I thought they did a good job with that. I don't think they did a good job of explaining why he lied about not being at the murder scene at the time. And to me, that's a critical piece of evidence. Maybe there isn't a good explanation for that. But all in all, I thought they did as good a closing generally as you're going to be able to do under these circumstances. And then we get into the rebuttal, and it took us, I think, a sillier turn. And I have made fun of theories, not necessarily by the defense, but at least on the internet, about the angry tiny cartel members. Let's blame it on his other victims, the Boat family and stuff like that. And in fact, the defense did try to bring that up in their closing, try to start speculating about a drug gang, and the judge sustained an objection to that. But you know why? Because there's no evidence of it, and it's completely ridiculous. And if they wanted to bring it up, they needed to have some evidence. It's not fantasy time in the courtroom, but it did turn into fantasy, and I'll be equally as critical of the state side because they actually said in their rebuttal that Paul took this Snapchat video as insurance against his father, that he knew he was exposing his father's seedy lifestyle and misdeeds, and his father might take revenge on him, might kill him, and if you do kill me, Dad, and you want to lie about it, then I've got this video. I'm taking this video. Okay, that video just shows him literally trying to capture the dog's tail on it and then arguing with his parents about what kind of animal the dog has in its mouth, chicken, guinea, whatever. That's it. There's no coded message about insurance on this. That's absolutely ridiculous. And maybe he meant it as some kind of metaphor or whatever, but I'm just telling you what he said. Let's listen.
Paul knew. Dad, I got some insurance. I got some insurance. Not the kind of insurance you've made money off of, an insurance some clients you gave back and some you didn't. I've got some insurance on you. I don't know why you killed me. I've made some mistakes. You heard a lot of good things about Paul, too. I know I put your life, open your life, your fake life, with this boat case. Your finances are coming out. I know that. But if you go lie and say you weren't down here, I got you. I don't know when it'll come out. Maybe you'll go ahead and lie. But this is going to come out. Paul had that insurance on him. And maybe that's why he was worried about that phone. And you can't make that up.
Yes, I mean, that's absurd. That's more absurd than the cartel theory. It's absolutely, completely bonkers to suggest that the son took that Snapchat video for any reason other than the subject in the video, and especially that his dad was 2 minutes away from murdering him. There are a lot of other things you could have done than take a Snapchat video if that was your concern. But he did top this by bringing in Bubba into this insurance plan. So Bubba, he says, Bubba knew something. So Bubba grabs this chicken because it's going to force Alex to say something, which will get Alex's voice on the video. So now I grew up with Lassie, which was supposed to be a pretty smart dog, but Bubba's got it all over Lassie because Bubba is aware that Paul is taking Sorry. Bubba is aware that Paul is taking a Snapchat video of Cash's tail, but he's really trying to get insurance on his father. And Bubba's aware that that might not work really well if they don't get his voice on there. So Bubba quickly grabs a chicken, and that causes Alex to say something. So thank God for Bubba. You think I'm making it up? Listen.
You know, some people say they got a sixth sense. You think Bubba knew? You think Bubba knew something? He got Alex to say something. Bubba! Thank God for Bubba.
So I'm sorry. I find this a disappointing way to close out your case if you're the state, because it's ridiculous. Whether it's meant entirely literally or not, it's just ridiculous. I mean, you'd have to be a drooling buffoon to be persuaded in any way by what this guy is saying. So is that what he sees when he sees the jury? Or am I just being an elitist? I don't know. But I like things to be backed by evidence. And I say that for the defense with the fantasy cartel stuff. And I say that with the state with the even more ridiculous idea that the video that Paul and Bubba were working together on this video to make sure that Alex would get caught, because that's stupid. So I don't find that the state covered themselves in glory in this case, even though I think they have the right defendant. And it would not surprise me as the jury begins deliberations if they come back with a not guilty verdict. This could go either way. I wouldn't bet $1 on it. There are material mistakes in the state's investigation. There are really bizarre decisions on the presentation of the trial. And the ending of this closing to me would be insulting to somebody who has a couple of brain cells activated. We'll just have to see how this goes. Thanks, bye.